Well, I appreciate everybody tuning in to this webinar. Will, thanks for trying to do this with me. I hope technologically we're able to make this worthwhile. But Senate Bill 85 goes into effect July 1st, 2020, and there's a lot of changes made to Kentucky's DUI law, specifically as it relates to ignition interlock. And of course, I've got Will Zevely here, the Dean of DUI for the state of Kentucky. Will, thanks for doing this. I think this is a good idea on both of our parts.
And this is the second year of Mr. Suhre becoming an editor in the Kentucky DUI law book, and we're glad to have him aboard.
Well, I appreciate that. Just riding on your coattails, Will. But I think between the two of us, we've got a pretty good idea of what's going on with Senate Bill 85, and we have had a lot of questions ourselves posed to us, and I think that putting this together is going to give a chance to not only answer some of those questions, but also to let folks know about our September 2020 KACDL Advanced DUI Seminar, where we'll delve into all of this in much greater depth than we can on a quick webinar. So with that being said, Will, I've got a PowerPoint presentation that we put together. So let me pull that up here, share it, and hit the play button. Can you see that, Will?
I can, yes.
All right, good. So, maybe we could just kind of walk through the ideas here of some of the basics. And, if there's any questions at the end of the video, we'll have an email address that you can send an email with those specific questions, and Will and I can look at those and try and answer them sooner rather than later, but for sure include them in our presentation for the KACDL seminar in September, and we'll have information at the end of this webinar about that as well. So, Will, you want to talk about the requirements of the device at all?
So the change that I can see, which is very obvious, is that now under the new law, there's going to have to be a camera, there has to be a log date and time, and there is a picture that you have to send in when you get the interlock so they can verify that you are the person that's supposed to be blowing into the machine. Joe?
Yeah, well, and so in one respect, it could be a good thing, right? Because if you have your car dropped off for service, I've run into this before. You have your car dropped off for service and there's a fail on the machine, but there's a picture of your mechanic that's blowing into it. That saved a client on more than one occasion. But at the same time, now the state's got its data picture of you and is comparing these results, or the results rather, with the photograph. So I guess it cuts both ways.
Next.
So we have three types of licenses, and this is kind of an interesting situation with the drug DUIs, but we have your standard or normal driver's license, a hardship license, and an ignition interlock license. So the hardship has not gone away under Senate Bill 85, but it's severely restricted. So in the past, if one were convicted of DUI, they could wait on a first offense of 30 days and then apply for a hardship license for driving privileges for work, for example. Now you can't do that if the DUI is alcohol, but you can on drugs, right, Will?
Yes. Well, say that again.
So if you have a DUI conviction that's alcohol related, you can no longer get a hardship license after July 1st, 2020. But if you're convicted of DUI from drugs, you can get a hardship license.
That's accurate. And remember that even if it is alcohol related, there's nothing that prevents you and the prosecutor from making a deal who wants a conviction to plead, even though it's alcohol related to a drug DUI. So you can get the hardship. They're cheaper than the ignition interlock, but there are restrictions as to the reasons that you can drive.
Yeah, and you wouldn't also be eligible then for the incentive period. So on a first offense, you'd have to serve the full 6-month suspension, as opposed to the possibility of getting it reduced to 4, which we'll cover in a slide coming up here.
Next.
Yeah.
Go ahead. You want to handle that one?
Sure. Well, so pretrial suspensions, the reason for imposing a pretrial suspension stays the same. So there's no suspension if you take the test. on a first offense, regardless of the result. So if you take it and it's under, or you take it and it's over, there's no pretrial suspension that's imposed. But you are suspended on a refusal for a first offense, or a test over, or a refusal on a second or greater offense. And of course, the look back period now is 10 years. So when we say first, second, third, or fourth, we're talking about the number of offenses within a 10-year period. That hasn't changed as far as the imposition of the pretrial suspension. What's changed, though, is the pretrial ignition interlock. So, and I guess this really changed in the last amendment. What was it, 2017, Will, with the introduction of the IID for pretrial privileges?
Yes.
But now the wording has been changed a little bit, and quite frankly, our discussions about it left a little bit of confusion, because if you look at the way the statute's written, it seems to make an ignition interlock device discretionary on a first offense refusal, but mandatory if there's a second or greater offense, or if there was an accident, an injury accident, even if it was a first offense. Will, do you have any thoughts on that?
No, I think that's accurate. And if you read it, the way the entire section reads, it's pretty apparent that they want everyone to have an ignition interlock. So even though it says with refusal it's discretionary, actually, I think if you read the whole thing together, that really they want it to be mandatory. Why they didn't put it in there, I have no earthly clue.
Yeah, it's a wording issue, in my opinion. It could have been clear, but it is what it is, and we'll have to deal with it. So my position on this is that everybody should consider applying for ignition interlock, that's subject obviously to a pretrial suspension, but should consider applying it arraignment, because that starts the first portion of the incentive and compliance period. And we'll talk about this a little bit later in the presentation, but there are important timeframes as far as a 6-month suspension on a first offense that can be reduced to a 4-month suspension if the person has 90 days of no interlock violations. Well, that 4-month suspension or 6-month suspension starts at the arraignment period, at the pretrial suspension period. So if you wait until there's a disposition on the case, which might be 30, 60, 90 days later, that person is going to be suspended, not having any driving privileges and not earning any credit towards the incentive period. And so I would say you want to strongly consider it at arraignment, since that's going to give the person the most time to get that 90-day credit, or 90-day period where they get that credit then for 2 months of interlock.
Agree 100%.
Length of suspension, this is different. So now we're 6 months on a first offense, 18 months on a second offense, 36 months on a third offense, and 60 months on a fourth or greater. And again, that's within a 10-year look back period.
Now,
So
the significance here is to understand that suspensions are no longer with the courts. They're through the transportation cabinet. So if you're convicted, the court determines if it's a first, second, third, fourth, or whatever, but the court must impose the maximum suspension at sentencing.
yeah, no longer a range to be established. It's simply, this is the suspension.
So the court can't say, oh, well, we're going to give you 4 months instead of 6 months on a first. They have to give you 6, then you have to work through the incentive period to get the benefits of the 4, which we will learn in a few minutes is a problem.
Yes. So talking about incentive period. So if you are convicted of a first offense and given the 6-month suspension, which is what the analysis is, that can be reduced to 4 months if you have no violations for 90 consecutive days. Second offense, 12 months, reduced to 12 months. Third offense, reduced to 18, and fourth or more, reduced to 30 months. But the consecutive days goes up to 120. It doesn't change from a second, third, or fourth. It's either 90 on a first offense or 120 for everything else. This is the part that's a little bit challenging. So the question is, when does the compliance period start? Well, for the sake of argument, let's just say client has a DUI arrest and arraignment on August 1st. They're suspended August 1st, and they're able to get an ignition interlock put on that day. If they go 90, it's a first offense. If they go 90 days with no violations, have they now satisfied that compliance period to now reduce the suspension ultimately to a 4-month period? And I think at this point, the transportation cabinet is going to say no, that would not happen that way, because according to the KAR, the compliance period starts immediately prior to the end of the incentive period. So the incentive period, I guess we need some definitions, right, Will? The incentive period is what can the suspension be reduced to? So on a first offense, it can be reduced to 4 months. So that's the incentive period. So if we go back 4 months on a first, 12 months on a second, 18 months on a third, 30 months on a fourth. That's the incentive period. That's the shortest your suspension can be if you don't have any IID violations for that consecutive days period.
So what the transportation cabinet wants to do, and Joe, if I say anything, Joe understands this better than I do because I don't really get it. But if you want the incentive period, like on a first offense, where it can be reduced from 6 months to 4 months, what the transportation cabinet expects is 90 consecutive days from the day that you are eligible to get or to get the reduced sentence. So they want to look at it and see that you've been clean for 90 days. Then they wait 1 more month and then you get your license.
Right.
But did I say that right?
Yeah. So like look at the third bullet point here. In other words, on a first offense, you have to be violation free on days 31 to 120. And on a second offense, you have to be violation free for months 9, 10, 11, and 12. It's the end of the incentive. I'm sorry. It's the end of the incentive period is the compliance period, not at the beginning. So in other words, if you went the first 90 days with no violations and had a violation on the 91st day of your suspension, then you don't get your license back early, period. Because you have to have 90 consecutive days on the last portion of the suspension in order to take advantage of that incentive period.
So you may save a month, but you're not going to get the entire incentive period. And all I can tell you is the statutes are not written that way. And I don't know whether we deal with administrative appeals in this PowerPoint, but if you come to the seminar, we'll lay that out for you, because you do have a remedy if you think you're getting screwed over by the transportation cabinet, which you will be.
Yeah, we don't have it in this PowerPoint, but we'll have all the paperwork and the process to go through the administrative appeal, because this is an issue I think that's going to need to get litigated across the state. So here's the chart that comes out of the KAR that shows you, for example, first offense, 6-month suspension. The incentive period is 4 months, meaning you can reduce that 6-month suspension to a 4-month suspension. But 1 month after the ignition interlock license issuance is when that period begins. Same thing with a second or third. It starts 8 months or it starts 14 months after. This is another issue that I think is really going to be a problem and really difficult to enforce. It is possible to get an ignition interlock device employer exemption, meaning for whatever reason, landscapers always come to mind. If you have a landscaping job, you have an ignition interlock device in your personal vehicle, you drive to work, but then you need to drive a company pickup truck to a job site. You can get that exemption. You'll be allowed to do that with no IID in the employer's vehicle. But here's the rub. The person that has that receives no credit towards their incentive period for the days they utilize the employer exemption and drive the employer's vehicle without an ignition interlock device.
Now, how in the world are they going to enforce that? And how in the world are they going to keep track? And if you get it, or you are doing that and you have permission to do it, what happens on the weekends? Are they going to give you back 2 days and just take away 5 of the credit? Or are they going to enforce it at all? Or how in the world is this going to happen? Because all I can tell you is if there's a chance you're going to get screwed. You're going to get screwed, and the transportation cabinet's probably going to do it. Next, you cannot be the owner of the business. So if you are the one that has control of the company car and the company is your company, you can't drive without an interlock on the business vehicle. So whether you have to incorporate it or do something to get control out of your name and get it in your wife's or somebody else's, it's an issue.
Yeah, and then the other question I have that I don't think is answered at this point is if you need 90 consecutive days of no ignition interlock violations, but you don't get credit towards your incentive period for days that use the employer exemption and drive it, can you then get consecutive days at all? How's that going to be interpreted? Or do they just skip that day? So if Wednesdays and Thursdays I need to drive my employer's vehicle, then am I not getting those credit towards the 90 consecutive days on those 2 days? Or do I not get any consecutive credit at all because there's an interruption in it? And what if I don't drive my employer's vehicle that day? Is it my job then to keep a log of the days I actually drive and have a notarized statement from my employer saying Joe did not drive on Thursday this week? It seems almost unworkable. Bunch of new forms. So here are the names and the form numbers for the transportation cabinet. So different applications. I'm assuming this will. I don't know the answer, but when I apply for an IID for a client now, I use an AOC form.
These are the AOC forms.
Yeah. So they have a transportation cabinet number on it, and they'll be available from the transportation cabinet's website. I think I have a link to it in the later part of this presentation.
And some of these forms are kind of tricky to fill out. So we will have the forms at the September 18th seminar. We will go through how you have to fill them out, the mistakes that you can make, and the consequences for making mistakes that it'll have on your clients. So the way this bill is written, trust me, fees are going to be larger in DUI representation because there's so much more to do, and you're going to have to slide over and do some administrative appellate work to get these things lined out. And ultimately, you could end up in the Court of Appeals or the Supreme Court for that matter.
Yeah, but one of the things that we're going to do is we'll have this together in a nice little package. So it'll give you the procedures you need to follow in your office. It'll give you the forms that you need to fill out. We have some client-facing forms when you do an intake on a new client to get the information you need for all of this up front, so that it's even though it's more work, it's at least streamlined. Will, this is kind of the ex post facto stuff we were talking about on the choice of law. You know, one of the questions that popped up was if a client's charged before the effective date of this bill, but sentenced afterwards, then which law applies? And I guess the short answer is it's player's choice. It's the defendant's choice in the negotiation process as to what law is going to apply as it relates to driving suspensions.
And the KRS is 446.110, which says that the penalty is mitigated by the new law. You can take effect. Certainly, you want to take effect of the new law if you have a third or fourth offense DUI, because the license suspensions are dramatically lessened.
Yeah, and you know, if you have a jurisdiction like, say, Fayette County, that'll give a 45-day suspension with no hardship license, depending on your personal circumstances, that may be better than 4 months with ignition interlock. So at least for the time being, that's an option. And but if you are, if one is arrested after July 1st and then subsequently convicted, there's no choice. All right, here are some of the resources that we've got. The drive.ky.gov will have all of the IID forms up. There's a link on my website to the attorney resources. We've got a sentencing cheat sheet, and we'll have a copy of this slide deck on there as well. And then if you go to kacdl.net, you can register for the September 18th, 2020 Advanced DUI Seminar to learn more about this. On KACDL's site at the top on the right, it says events. Just click on that and scroll down to September 18th, and it'll have a link to register there. And we'll have, again, all of this information times about 5 in terms of the depth of it. And then, like we said, a resource packet available as well. So got to throw this in. Will, the author of Thompson's Kentucky Driving Under the Influence Law Handbook series. We cover all of this in chapters 4 and 11. It's also throughout the book in less detail, but in chapters 4 and 11, it talks about pretrial suspensions and privileges, and then obviously in sentencing.
So the new book is going to the press, or I don't know when it's going to the press, but it's going to the publisher mid-July. So hopefully they'll have it out certainly before the end of the year, which will have all this in there.
Yeah, I think it comes out in October. It's actually in there now too. So the 2019-2020 version, which is the cover that you see there, the information is in the book now. It'll just be even more in depth as the KARs have come out since we published last year's version. And Will and I went through and rewrote a lot of the stuff. So it gives you even more information for the 2020-2021 edition. So, and then the last shameless plug, this is the Senate Bill 85 Advanced DUI, September 18th, 2020 at kacdl.net. So I hope this was useful. And like I said, at the end of this, we'll put an email address in. If you have specific questions that you want answered, please send us an email and we will do what we can to get those answered and certainly incorporate them into the presentation coming up in September. Will, any final thoughts?
Nope. It's a very complicated law. It was put together pretty quickly. There's a lot of unanswered questions. Joe and I met with the people that did the regs. They were very helpful, very kind, and did their best to explain their position. Because of our meeting, we took out or had them take out some of the things that are in there, but really they haven't changed their opinion on how you calculate this incentive period, which is a major issue as to how the incentive period is going to get credited so you get the reduced license suspension. We'll have some thoughts on that, plus some issues and thoughts on dealing with out-of-state licenses and people who live in Ohio who get Kentucky DUIs, and likewise people who live in Kentucky who get Ohio DUIs in reference to use of the IID.
Yeah, we'll have all of that and forms for use and the process that needs to be followed with the transportation cabinet to get all of that straightened out and keep your clients on the road lawfully.
So we look forward to seeing you at the September 18th seminar, and it will be in Northern Kentucky. We think it's going to be in Burlington at the old courthouse, but we will let you know, follow that on KACDL's website.
All right. Thanks so much. Appreciate everybody tuning in.